Hi, it's Musharraf Hussain with the subject of interpreting taxing statutes. Our today's topic is meaning of law. Before we go over the meaning of law, let us have a discussion on this legal maxim, ignorantia juris non excusat. Whenever we talk about any legal maxim, we should know that these are also principles often derived by courts or jurists, rather derived by jurists and recognized by the courts. These are often in Latin and invention of a medieval period of English. Nowadays, the tendency is to speak in simple English only and avoid the maxims in Latin. But still, we find because of its crispy nature, its usage. Now, let us come to this ignorantia juris non excusat. In simple English, it means ignorance of the law is no excuse. This actually implies that no one should escape by breaking the law or the breach of law or violation of law. Because someone should not make an excuse that I did this or I did not do this because I was unaware that there was a law to do it or not to do it. So I can say that this principle is the very first principle of law because if I remove these principles, then there is no meaning of initiating, of recognizing, of discussing the law. So this legal maxim, as we have seen, that signifies importance of legal awareness means we should know what is the law of the land as we are bound by that law. Now coming to the definition of law, there are a number of definitions of law from different schools of law. Different jurists have given different definitions. An attempt has been made here to assimilate all those definitions and present in some simple English a definition which may cover all those schools. Now, law. Whenever we are talking about law, we are talking about jurisprudential law, which is a species, a kind of social law. We are not talking about natural law, such as law of motion recognized by the Newton. Then other law like earth revolving around the sun. These are natural law, natural principles, which is we can say that it is the functioning of nature. Law for our purpose is the functioning of society. So whenever throughout the session we are discussing law, we are talking about this jurisprudential law. Now, is also an important word and need to be distinguished from out. Something is and something ought to be is to be recognized because as we said that there are number of schools of law, and if we put all those schools of law on a continuum, on a stream, then we find on the one side is positivist and on the other side naturalist. Positive school of law recognize that law is the dictates of sovereign, command of sovereign. On the other hand, natural school of law says that law is the dictates of reason. So their focus is more on that what law should look like or what the law should ought to be. On the other hand, positivists are of the view that whatever the commands is issued by the sovereign, that is law. So we need not go and see the content of law, that whether it is correct or not. So natural law, of course, discusses the ethical view of the law, while the positive law discusses the practical view of law. Okay. Next comes the embodiment. We should recognize that legal principles are not a standalone principles. It is the entire corpus juris, the entire body of law, of which a particular, say, law of contract. Law of contract does not mean that it stands alone on its own. There are a number of other law. Similarly, say income tax law. Now, if we are studying income tax law, then we cannot say that though it is said to be as a self-contained code, but a number of law, we have to find where it find its places. Suppose we have to see it in the perspective of constitutional law, in the perspective of interpretational law, and other laws. So we often call that it is a body of law in which a particular law finds its place. Now come to the word principle. Principles are universal facts that guides our behavior. Just like that, we know that if we touch the fire, it will burn our finger. So the principle is that don't touch the fire because it will burn your finger. So law is also like that kind of principles that guides your behavior. Now the word self-preservation. Self-preservation, though rarely spoken, is a wider term than self-interest. Of course, social law is made of self-interest law, but when we call about self-interest only, then something we lack, because self-preservation means not only our interest. I mean, it is in our interest that we keep the interest of others also alive, because we as an individual cannot live in the society. As we said that it is a social law, it is a law of the society. So society is not composed of only one person. So if we pursue only self-interest, our interest, so it is in our interest that we take care of the other interest. We need to be. Suppose if a man is put on an island, he cannot exist for long. So self-preservation can be said that it is a self-interest keeping the interest of others too. Now, recognized word means recognition. A principle has to be recognized. If it has not been recognized, it may be ethical principle, a moral principle. But in jurisprudential law, it has to be recognized by some authority, and the authority is mostly a state or the sovereign. Then the word is applied. Applied means it has to be applied. A principle has to be applied. Applied has two connotations. First, it is applied by the administrator, by the executive, and second, it is applied by the court while deciding any dispute. So, the principles need to be applied. Of course, society means All the executives, all the courts, and even the legislative body, all are part of society. So, society here is a wider term to include all those bodies who recognize and apply the law. So, one can find that we are leaning towards the law of positivist, with the exception that here we are counting the principles of self preservation, which is actually the foundation of natural law. Now we come to the contents of law. Law is composed of act of legislature, delegated legislation, and judicial precedents, laying down, of course, legal precepts, enjoining rights upon and seeking obligations from members of the society. So, after discussing the definition of law, the nature of law, we can say, we will see the actual content of law here. So, there are three contents. First is the act of legislature. Second, the delegated legislation. Delegated legislations means the legislation made by the executives on behalf of the legislatures. And third, the judicial precedents. Some principles are recognized by courts while interpreting the law, and these are also a recognition of principles. So it is also a part of law. What all this law does is that it lays down legal precepts, legal principles. All those legal principles enjoins, it gives rights to us, and it seeks obligations from us, from the members of society, we being a member of society. Now we have to see in this perspective what is rights and obligations. Rights have two shades of meaning. One is claim and second is power. A claim means you have a right and someone else has a duty, whereas a power means you have an ability to alter the situation, whereas the other is liable to be bound by that. So, rights has its correlative as obligations, with again two shades of meaning, duty and liability. Now the sanction of law. Sanction of law ensures enforcement of rights and discharge of obligation. Sanction here means fear of law. The fear of, rather the consequence of not following the law. Because if a sovereign simply lays down the law and does not make arrangement for its enforcement, then of course there will be no meaning to law. So sanction of law ensures enforcement of rights and discharge of obligations. Suppose if I am having a claim of 100 rupees with Mr. X, then if Mr. X knows that if I do not return rupees 100, I will not be bound by anyone, I will not be punished. So naturally he may avoid payment unless he is a very ethical person and comes to me and pays back my money. So law, when we are talking, as we have seen that it is a jurisprudential law, provides for the measures against those who violate the law. So these measures are sanctions. Similarly, discharge of, as we have seen, the rights are correlated by obligations. So enforcement of rights naturally means that someone has some obligations to do it. Thank you.